Good morning. It's January 22nd, Monday. This is Ron. Welcome to Storytime. And today is like a little extra, one of my little extra Storytime episodes. And so this morning, what I wanted to talk about was my experiences and offer some kind of insight, perhaps, to my listeners about filing a lawsuit, and I'm not talking small claims cases. Some years ago, I was employed by Southern California Edison. My employment was terminated. I went to the Department of Fair Employment and Housing, filed a complaint, which was not validated, and then I went ahead and sued Southern California Edison on my own, without a lawyer, for 5 causes of action. It ended up that we filed cross motions for summary judgment, and the judge found in Southern California Edison's favor. I appealed all the way to the California Supreme Court, but did not prevail. So the lessons learned on this is, one of the things that I wanted to make sure that I let you know is one of the best books, if you're going to sue somebody on your own, and for either a superior court action, an unlimited or a limited civil case that's more than a small claims case, then the best book I recommend for really getting the ins and outs of how the system works is a book called Sue the Bastards. I don't remember the author's name right now, but I'm sure if you look it up on Google or just go onto Amazon and put in Sue the Bastards, you'll come up with it. One of the most interesting things in the book was the idea of practice guides. Lawyers have practice guides. They either have them in book form or they've got them on CD. And a practice guide is basically a template so that the lawyer doesn't have to reinvent the wheel every time that he wants to file a motion, or he is going to put in a new complaint on behalf of a new client. All he has to do is consult the practice guide, and it has all the language in there, and it just has blanks to put in names, dates, and places. And so that's what I ended up doing, was using practice guides throughout the whole process in order to be able to keep up with what was going on and make sure that I could make a credible appearance in court. So the biggest takeaway I had for the reason that I lost the case was that I did not understand what constituted evidence. Okay, I thought it was going to be a common sense issue, that things were a certain way and people acted this way or that way, and all I would have to do is relate those, maybe do not a deposition, but write it down on paper, basically, and swear to it. And put it on paper, swear to it, and then that would be good enough for evidence. In my particular case, it wasn't. There is a specific type of evidence that the court is looking for. I didn't even find out about this until several years after I lost the case. But because the reason I lost the case, judge said there was no, or insufficient, or no evidence. And I was baffled at the time. I thought I included all kinds of evidence, but it wasn't evidence that the court considers valid. And that's vitally important. Unless you understand exactly what constitutes credible evidence in court, you're not going to get anywhere. You can do all the practice guides in the world, and without the proper evidence, you go nowhere. So make sure that you find out what constitutes proper evidence. There should be books in the law library on that. Also, what you can do, one of the other takeaways that I got was when I was filing an appeal, and clerk that I was filing the appeal with, told me that he didn't tell me as like advice to. He put it in a very general way because one of the things you learn when you're filing a lawsuit is that clerks are not allowed to give advice. You're going to find nobody's going to give you advice when you're filing a lawsuit. You're on your own. But he gave me advice anyways, but he did it in a rather hand kind of way. He said, you know, if I was filing a lawsuit, what I would do is I would go to um, do some research and find a case that was exactly like mine and study that case inside and out and know it inside and out. And that way I would be adequately prepared. So that's the same thing I would recommend. If you're going to got a case that you want to bring, might be for wrongful termination, it might be for discrimination, and you really want to get a good understanding of what's going to happen, how it's going to happen, go to a court, and they have a computer terminal, and you can look it up. Just put in a search term, you can put in discrimination, or you can put in wrongful termination, and they will bring up all the wrongful termination cases. And then what you do is you want to look through those cases and find the case or cases that are as close to your case as possible, exact if you can get it. And then what you do is you go to the window and you make a request for copies of documents, for copies of the files that you're going to need. So that way, all you have to do after that, between the practice guide and the papers you have from the court, you should be able to come up with a very, very credible case and increase your chances, more importantly, of winning. So, and let's see if there's anything else I was, there was something else in terms of the appeals. It's a lot of paperwork. It's, if you have a home office or something like that, I was doing everything at Office Depot, which made things rather difficult. But if you've got some place at home where you can do this, if you got your own printer, that's even better, because I was ending up typing stuff at Office Depot and then having to run over to the printers, type in one place, go to run over to the printers to print it out, and it was time consuming and a little bit on the expensive side. Some of the biggest costs were the cost for actually filing the lawsuit. I think was $250. Now I think for an unlimited civil action, it's over $300 to file a suit. The other big expense is in doing a deposition. You don't have to do a deposition. You can also do interrogatories. And again, in the book, Sue the Bastards, they explain what interrogatories are. But basically, it's you have a whole bunch of questions that you're asking in writing that you send to opposing counsel, and then they get those questions answered for you. And so you can do the deposition. Usually costs around $500 an hour, but that's if you use the standard legal stenographer. That's what people usually do, is they'll have a legal stenographer come in. They're charging not only for being there and transcribing what's going on, but they're charging you for putting everything together and into proper legal form, so to speak, and printing it out and sending copies to the parties involved. But there is a rule that says that you can get a notary public. Finding one that's going to be willing to do it might be a little bit tricky, but you can get a notary public to go ahead and transcribe a deposition for $20. So don't think that you have to go out and spend $500 an hour for a legal stenographer. You don't. And $20 is not $20 an hour. It's $20 period for the day, for as long as that deposition lasts that particular day. If you got to call him back for another one, then it's another $20. But it's still a heck of a lot cheaper than having to spend $500 for the entire deposition. So, but I, even though that I lost, I feel that I gained a lot, because I got a good look at being inside the judicial system, at filing a lawsuit, kind of looking a look inside the lawyer's world. I didn't get much time in front of the actual trial judge because we went in for the initial, to set the court date, and then we went in again for the cross motions for summary judgment, and those papers were filed, but you just go in and basically get the judge's verdict or ruling on it. And but I did also, when I filed a excuse me, an appeal to the California Court of Appeals, I got the opportunity to make my arguments in front of a 3-judge panel. So that was interesting. I liked doing that. So the other thing that you can do as the last piece of advice here is, if you're going to go ahead and do this and you're going to be appearing in court in front of the judge, one of the ways you can take the edge off your nerves so that you're not as nervous about the situation is what I call doing reconnaissance. That means pick a day, go into court, and sit in a courtroom and just watch what goes on and see what happens, how it happens, when it happens, what order things are done in. Go out, and on the bulletin board are a list of all the cases that are going to be heard by a particular judge. So when your case gets assigned to a particular judge, then you go to their courtroom and then you look on the board and see where your name is. And that'll tell you, if you're at the top, you'll be one of the first ones called. If you're near the bottom, you're going to be one of the last ones called. So, but doing a little bit of reconnaissance is going to make you feel a little bit more comfortable about the whole process and make things better overall. So, anyways, this was the Story Time Extra for today, Monday, January the 22nd, 2018. And tomorrow, I am going to be reading from another issue of Imprimis, which is a publication of Hillsdale College, and it's called The Left's War on Free Speech. So until tomorrow, thank you very much for joining me, and have a great day.